Hi, Russell Crumbley with the law firm of Crumbley-Blackwell-Wisda and Associates. Today's question comes from a guy who was involved in a car wreck. He was named the at-fault party and he did not have insurance. Damages to the other car were $12,000, and he has received notification, since he has not satisfied that claim, from the state of Alabama that his Alabama driver's license is going to be suspended. Liability insurance is mandatory in the state of Alabama, and if you have a wreck and you cause damages and you don't have insurance and you don't satisfy the claim, the state will suspend your driver's license. So in this situation, he's got about three options. Number one, of course, he can he can satisfy the claim, pay $12,000, get a release from the injured party, present that to the state of Alabama, and get his driver's license back. Of course, I would imagine that if he had the money to pay a $12,000 claim, he would have had the money to have had insurance, and probably would have. Second option would be to have a law firm, and we could do this, negotiate a reduced amount for a satisfaction of the claim. We have been able previously to get a claim reduced as much as 90%, so that our client actually paid a dime on the dollar. In this case, such a situation will be $1,200, satisfying a $12,000 claim. Now, obviously, we have not been able to do that every time, but if you can get it reduced to an amount you can afford, you can get your driver's license reinstated that way by getting a release as a part of the negotiated deal from the injured party. The third option is to file a bankruptcy, provided alcohol and or some other intoxication was not the reason for the accident. You could get that claim discharged in bankruptcy. You can't discharge a claim in bankruptcy for an accident that involved intoxication, but assuming that's not the case, you could get that discharged, and you could take the resulting paperwork from the bankruptcy discharge, present that to the state of Alabama, and get your driver's license reinstated that way. So I would actually say to both parties, either party, the injured party in this case, recognizing that the party that injured you has the option of bankruptcy. $1,200 on a $12,000 debt may not seem like much, but it beats the devil out of zero. So this hopefully not only answers the question for the fella that asked it, but gives a little bit of insight to someone who may find themselves on the other side of this scenario. Hope this helps. And if you can't find the answer to your question, send us a question. We'll be glad to answer it.